Your life, sir. Madam, allow us. Madam.
One second. Yes, you can unmute now.
Sir. Sir, go ahead.
Good evening to all of you. Now we go into the biggest chapter as far as the specific relief act is concerned. It is called specific performance of the contract. It is laid down in section from section 9 to section 24 of the specific relief act. Section 9 says, what are the defenses? Suppose let us say there's an agreement and there is a contract between the seller and the purchaser as far as immovable property is concerned or anything is concerned. And there, the question is, what are the defenses that are open to a defendant? After all, there are two parties to the suit. One is the plaintiff and another is the defendant. And what are the defenses open to the defendant? As for when A brings a suit for specific performance, for enforcing a promise or enforcing an agreement, then what are the defenses which the prativadi or the defendant can take? This is laid down in section 9 of the specific relief act, which says, again I'm repeating it at the cost of repetition, the vitiating elements of contract laid down in section 15 to 22, that is coercion, misrepresentation, undue influence, fraud, mistake, unilateral and bilateral. So when these elements are present, at least let us say one of the elements are present, then the defendant can allege and also defend the suit by saying that one of the elements is present, and he can also say what are the circumstances under which that particular vitiating element is involved, and he can excuse himself from performing the terms of the contract and also oppose the suit which is filed by the plaintiff.
Yes.
So the defenses that are open to a defendant is that vitiating elements of contract, that is coercion, misrepresentation, undue influence, fraud, and mistake, unilateral and bilateral, which is provided under section 15 to 24, or I mean 15 to 22 of the Contracts Act, he can plead it as a defense. Second thing is, there is a saying that the plaintiff himself is at fault, or he has acquiesced at the breach, or he has not provided the proper facilities for performance of the contract, then in that case, the defendant can successfully plead, saying, sir, these are the defenses which are available to me. Please non-suit the plaintiff, and he can defend the suit, even is assuming for a moment the plaintiff brings the suit for enforcement of the contract. So the various defenses is, again, when I dealt with the Sale of Goods Act, also the same defenses were there. The same defenses are available to a defendant or the prativadi, the person who defends a suit which is brought against him, and these defenses can definitely be raised, and they have to be pleaded and they have to be proved. So the question is, the defendant can excuse himself from performance due to various factors. Or let us say the plaintiff himself is a violator. Plaintiff himself has not followed the terms of the contract. He has not complied with the terms and conditions. He has not complied with the terms and conditions, and he is a violator. And it's something like a kettle calling the pot black. When he himself is at fault, he cannot blame the defendant as far as performance is concerned. All the valuable defenses that are available under the Indian Contract Act can be raised as far as the defendant is concerned in a suit for specific performance. It's a very, 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 very small section 9. This speaks about defenses available to a defendant. Now we go further, the main section, section 10. Here, I don't want to go into that aspect how the specific performance came into existence, common law courts, equity courts, so on and so forth. Earlier, either two, specific performance was not available as far as the common law is concerned. But this is a doctrine which is borrowed or which is initiated by the equity courts, which said when there is a contract, it has to be performed, however difficult it may be, in the letter as well as in the spirit, and that's the reason the specific performance has been enacted, where they say perform the contract specifically in the letter as well as in the spirit. That is what is called specific performance. That is the definition of the word specific performance. Section 10 says that as far as a contract is concerned, it can be specifically enforced at the discretion of the court. Maybe the word that was used was maybe specifically enforced through filing a suit for specific performance. But in 2018, an amendment was brought. It was the word may has been substituted by the word shall. You know the difference between may and shall, sir? May means discretionary. Shall means mandatory. So, whenever a suit is brought for enforcement of a contract, the court shall enforce the contract. Court shall not go back on enforcing the contract. In other words, it's mostly tilted more towards the plaintiff rather than the defendant. So the word may has been substituted by the word shall. Shall means it's mandatory. No longer it is a discretion of the court as far as specific performance is concerned. Once an agreement has been set up, it has it has satisfied all the ingredients of a valid contract, and the person who has filed the suit or wants to enforce the contract is a person who has been wronged or victimized, and the other person is the villain, or the other person has broken that contract or violated the terms of the contract or committed a breach of that contract. Law should not be helpless to come to the rescue of a person whose rights are trampled or whose rights are violated. And the idea of law is you don't make an agreement for fun's sake. You want a methodology through which you can positively enforce that agreement. And that positive enforcement is what is called specific performance. The far reaching consequences of the amendment in 2018 is no longer it's a discretionary remedy today. It is mandatory. It is a matter of right which is available to a person whose rights are violated. That's the reason the word may has been substituted by the word shall. Shall substitutes the old word called may. So, in other words, whenever a suit is brought for specific performance, the court shall enforce the contract between the parties. Why this has been enforced, why this has been introduced is if it is left to the discretion of the court, then what would happen is every person who tried to violate the terms of the contract, not perform the contract, negate the contract, or take some frivolous defenses in order to non-suit the plaintiff and rely on the discretion of the court to say that specific performance cannot be granted. So please remember, this is the only amendment perhaps in the Specific Relief Act which has been brought about by the Amending Act of 2018, and the consequences of that is the word may has been substituted by the word shall. Are you able to understand, please? So, 2018 amendment has got far-reaching consequences. So, here it is said in section 8. Then next one is so. So, first and foremost is in a suit for specific performance, what are the ingredients that have to be satisfied? I'm talking about prior to the amendment. There are two equitable doctrines which have to be satisfied. One is one who comes to equity must come with clean hands. Number two is one who seeks equity must do equity. What do you mean by that? That is, there shall not be any suppression, there shall not be any concealment, there shall not be any distortion of facts. All the facts will have to be laid squarely on the table so that the other side may be able to prepare his defense accordingly. Again, I repeat, Order 6, Rule 2 CPC says plead and then prove, not prove and then plead. So, first one is one who comes to equity must come with clean hands, means there shall not be any suppression, there shall not be any concealment, there shall not be any distortion, and all the relevant documents which go and probabilize the contract between the parties that has to be laid on the table. You cannot conceal anything, take the other side by surprise. Second one is one who comes to equity must come with clean hands. What do you mean by, I'm sorry, one who seeks equity must do equity. Suppose, let us say, there is a contract to purchase a property for 50 lakhs. You have already paid in advance of 5 lakhs, and 45 lakhs has to be paid on the date of execution and registration of the sale deed. What are the conditions of the contract, sir? The conditions of the contract is you must be ready and willing to pay the balance of the sale consideration on the appointed day, and then alone the seller is under liability to execute and register the sale deed in your favor. Then, second thing is, as far as limitation part of it is concerned, a suit for specific performance has to be under Article 54 of the Limitation Act. It says it has to be filed within a period of 3 years. Within a period of 3 years, in case the date is fixed. Date for performance is fixed. It is 3 years from the date fixed for performance. Sometimes it may so happen, sir, if the performance cannot be done immediately, I'll tell you the contingencies also. Where, suppose, let us say, on the day, of course, now you don't have the Urban Land Sealing Act, or you don't have the Land Sealing Act also, except you must come under the definition of the word unity for the agriculture land. But as far as dwelling houses or shops or anything is concerned, it is said it is 3 years period from the date fixed for performance. Let us visualize a situation. An agreement is made on 10th June 2024. Suppose it is said the transaction shall be completed within a period of 60 days. 60 days means 10/6/2024 to 10/8/2024. Within that time, you should perform your obligations and be ready with your money so that the sale deed can be executed and registered in your favor. Huh? Section 10, 9 I paid. So, as far as Section 10 is concerned, what all you have to prove as a plaintiff is one, it is an executory contract. What do you mean by executory contract? Executory contract means where some of the obligations are performed on the date of agreement, and the rest of the obligations have to be performed in a phased manner or within a specified time, and the money consideration which is agreed upon by the parties has to be paid or tendered to the seller. Or let us say in the meanwhile, let us say certain things cannot be done because the land has to be surveyed, it has to be localized, it has to be in conformity with the layout, or let us say some government permission or clearance is required for sale, or especially as far as agriculture lands are concerned, the permission of the collector is required for executing the sale deed, or let us say some exemptions have to be taken as far as exempting it from any provision of law, then till such time they are done. Or let us say the property is in occupation of the tenant, and the landlord, I mean the seller, undertakes to get rid of the tenant, evict the tenant, and give you possession of the property, or the tenant has taken 1 year's time to vacate and deliver possession. Till that 1 year period expires, the question is there is no performance of the condition as far as the seller is concerned, and the buyer is not bound to pay the money till the stipulations mentioned in the agreement of sale is complied with. So, in those cases, I'll come to that. Then I think most of you are aware of section 61 to 63 of the Contracts Act, which deals with novation, remission, alteration, modification of the contract. Suppose, let us say on 10/6/2024, you make an agreement. Let us say later on, because of certain subsequent events, this contract, new contract comes into existence, and on 10/10/2024, a new contract is entered into between the parties specifying certain terms. Can you tell me, sir, which contract has to be performed? Is the original contract or the later contract? When the old contract has been substituted by a new contract, there is a variance, there is a modification, there is an alteration, or there is a new clauses which are included, which are introduced. Then in that case, the obligations under the old contract comes to an end, and the obligations only under the new contract or the novatio contract, as it is called, has to be performed by either side. Why I'm trying to tell you all these things is Article 54 says if a date is fixed for performance, it is 3 years from the date fixed for performance. That is a limitation period. But the question is, if certain things have to be done as per the stipulations, certain clearances have to be taken, certain permits have to be taken, certain no objection has to be taken, or government permission has to be taken, or the permission of the collector has to be taken, then in that case, or the land has to be surveyed, land has to be localized, boundaries has to be fixed, cuddy stones have to be fixed, or let us say you have to get rid of the tenant, the seller undertakes to get rid of the tenants, then alone the contract becomes has to be performed. Then sometimes what happens is a new contract substitutes the old contract, introducing new conditions. Then in that case, the obligations under the old contract comes to an end, and a new contract comes into existence, and the obligations have to be performed as per the new contract alone. Then I'll also give you an example, sir. Suppose, let us say on 10/6, 2024, you enter into a contract and the sale consideration that is fixed is 50 lakhs. But that 50 lakhs is not payable immediately. 10 lakhs advance has to be paid, and the remaining balance of 40 lakhs has to be paid in a phased manner. For example, please remember, though we have money, because of certain problems which arises from income tax authorities, we agree to pay it in a phased manner. The next installment is payable on 10/8, 2024. Next installment is payable on 10/10/2024, and the last installment has to be paid by 10/12/2024. Please remember, can you say that it is time barred? No. Why? Because till the payment of the last installment, the period of 3 years does not start. It starts only from 10/12/2024 for a period of 3 years. That is, in other words, if a supplementary agreement is made, if a novatio agreement is made, the obligations under the new contract alone has to be performed, not the old contract is to an end. Suppose, just visualize a situation, sir. The last installment has to be paid by 10/12/2024, but the vendor receives the balance of the sale consideration, let us say on 10/4/2024, and 25, I'm sorry, 10/4/2025. Then what would happen, sir? That means any default that has been committed, where it has the last installment has not been paid on or before the stipulated date, and the vendor acquiesces at it and receives the balance on 10/4/2024. The question is the contract does not get wiped out, but you get a fresh period of limitation from 10/4/2025. I'm sorry, 10/4/2025. So Article 54 of the Limitation Act says that it is 3 years if the date 3 years from the date of agreement or the date fixed for performance, or please remember this proviso, you must always remember, sir. It says 3 years from the date when the refusal on the part of the vendor comes to the knowledge of the vendee or the purchaser. I tell you how. Before the date for performance comes, let us say you issue a notice calling upon the vendor to execute and register the sale deed. And let us say the vendor refuses to execute and register the sale deed, or does not reply to your notice, or does not take any action in relation to the contract. Then in that particular case, you will get a fresh period of 3 years from the date of your legal notice. That's how you save limitation. That is under Article 54 proviso. And the plaintiff also can take differences by saying, sir, under section 61 to 62 of the Contracts Act, the contract has been novated, the contract has been altered, the contract has been varied, the time for performance has also been extended, or certain other conditions are included. Then he says that the old contract has been substituted by a subsequent contract which alters the terms, varies the terms, modifies the terms, or novates the terms which are already agreed upon. Then Article 54 proviso comes to your rescue when you give a notice, sir. These are the terms of the subsequent agreement. The old agreement has been extinguished. As per the terms of the new agreement, I am prepared to perform my part of the obligations. Please come to the registrar's office, execute and register the sale deed. Then in that case, you get a fresh period of 3 years from the date of the supplement, as the date of the legal notice. So once the vendor does not reply, or the vendor does not execute and register the sale deed, then it is a case of refusal on the part of the vendor to perform his part of the obligations. Then you squarely come under the proviso to Article 54. I'll talk from the point of the vendor also, sir. As far as the vendor is concerned, he can say, sir, the original contract has not got extinguished. The time was the essence of the contract, and then the on the stipulated date he has not tendered the balance of the sale consideration. I have already given him a notice saying that the original agreement stands cancelled because of violation on the part of the buyer, and the buyer has kept quiet or not tendered the balance of the money. I was ready and willing to perform my contract by executing and registering the sale deed. Because of the fault of the purchaser not paying the money within time or within the time appointed, I am cancelling the original agreement. Please remember, in those cases, when the vendor wants to cancel or revoke the agreement, he has to give a written notice saying, sir, these are the points on which I am not going to perform my part of the contract. Then one more thing also arises, sir, doctrine of part performance. What is meant by doctrine of part performance? It is now no doubt not laid down in the specific relief act, but you have got a separate section in the Transfer of Property Act called Section 53A. Doctrine of part performance. What do you mean by doctrine of part performance? Doctrine of part performance means, suppose, let us say, by promising you that a particular property will be sold to you and open land is given to you. Let us put it this way. Then you construct on that open land and construct a pakka building with all amenities, and the seller keeps quiet without correcting you. You can say that you have been put into possession, though there is no written document evidencing the transaction. Since I have done something relating to the land and the seller has kept quiet without stopping me from making any improvements, I perfected my title by part performance of the contract. The rest of it, I'm prepared to do it. Please direct the vendor to execute and register the sale deed. That is where part performance can be pleaded. But for part performance to apply, you must do something relating to the land which is the part of the transaction. You cannot do anything which is not part of the transaction. The same land which has been given to you, open land, you have constructed a building there. The vendor keeps quiet, allows you to construct the building. Later on, he cannot plead and contend, sir, I have not permitted him to construct the building. He has done it of his own accord. Let him give the land, return the land with the structures to me. That is not permissible. So doctrine of part performance says when there is an agreement, and by virtue of that agreement you have been put into possession of the property, and after taking possession of the property you have improved upon the property, erected structures or improved the property, then in that case the seller or the vendor cannot avoid executing the sale deed. But again, I'm telling you, it is based on the equitable maxim. One who seeks equity must do equity. That means you must always be ready and willing to tender the money, pay the balance of the sale consideration, be ready for the registration, tender that money to the seller, and also make him aware of the seller's obligations under the contract. Then law will not be helpless. Law will come to your rescue and enforce the agreement, however difficult it may be for the vendor. Then one more question arises, sir. Suppose escalation of prices are there. Perhaps you know land values increase every day. For example, especially after the international airport had come up in Shamshabad, I still remember Shamshabad and Maheshwaram. No one used to dare go to that place because it was a thick jungle. But after the international airport came, there was a boom as far as immobile properties were concerned. Properties which are fetching only 1,000 or 2,000 per square yard plummeted itself to 1 lakh or 2 lakhs per square yard because of the land boom there, because being nearer to the international airport. But here, suppose, let us say, the seller makes a contract with me that he will he'll sell the property to me for 50 lakhs. Let us say outside next day itself, he receives an offer for 1 crore as far as that property is concerned, and he cannot avoid the contract by saying, sir, 50 lakhs is too meager an amount. Today the prices have gone up, things have gone up, cost of living has gone up. I don't want to sell it for 75 lakhs. I want to sell it only for 1 crore. That cannot be done. Escalation of prices is not a ground to avoid a contract. So, more especially after the amending act of 2018, it is said the court shall enforce the contract. The question, however difficult it may be, however irksome it may be, however hazardous it may be, and the escalation of prices is not a ground to avoid the contract. And what all you have to prove, sir, in a suit for specific performance is there is an offer, there is an acceptance, there is a capacity, there is consideration, there is free consent, and there is legality of object. There is all the ingredients of a valid contract laid down in section 6 of the Contracts Act have been satisfied. So I am not the wrongdoer. I am the person who is wronged by the other side. I am not the person who has committed a breach. The other side has committed a breach. Please compel him to enforce the contract by executing and registering the sale deed. Please remember now the scenario has changed. No more discretion is available to the court. Once a suit is filed for a specific performance, the court shall enforce a contract if it is proved and established. Court has no other alternative than to enforce the contract. However, it's somewhat difficult it may be to the opposite side to perform his part of the contract. One more thing you must remember is that a suit for specific performance would lie only in relation to executory contracts. Please underline the word executory contracts. Executory contracts is some of the obligations which are performed and the rest of the obligations has to be performed in a phased manner according to the stipulations laid down in the agreement of sale. Then in that case it is said the it is an executory contract. A suit for specific performance, please underline it arises or it exists only regarding executory contract. Then, if you take as far as executed contract is concerned, there is an offer, there is an acceptance, there is a completion of the contract. Nothing more has to be done. It is called an executed contract. In Urdu, they call it as Farok Nama. Farok Nama means it is something like what is called a sale deed. And nowadays, I think in Telangana area, there is a provision for Sada Bainama also. Sada Bainama means it's almost Sada Vikriya Patram or Sada Bainama. In that, what happens is there is no proper stamp on that, but there's the evidences the transaction intercede the vendor and the vendee. There is a provision provided under the Record of Rights Act that they can be validated by the revenue authorities on payment of the challan to the treasury, whatever is the amount payable towards the stamp duty, and it be validated by the revenue authorities as far as law is concerned. Even most of the Sada Bainamas have become Pakka sale deeds today. Why? Because they gave more importance to the transaction between the vendor and the vendee. And once it is validated, the question of raising any objection does not arise. In this regard, sir, I would be failing in my duty if I don't cite Section 17B, which has come by the Amending Act of 2001, where they say all contracts relating to immobile property, which settles the property, extinguishes the rights of the parties, or diminishes the rights of the parties, or which reserves an annual rent, has to be reduced to writing and has to be duly registered. So, an unregistered document, be it an agreement of sale or be it not an agreement of sale or anything, has to be in writing and has to be duly signed. Then you may ask me, sir, what is the stamp duty that has to be paid? I mean, sorry, what is in how much stamp it has to be engrossed? Please remember, more so after the Telgi scam, most of the people today, and even the registrar office or the concerned registering authority, does not accept non-judicial stamps. The document cannot be engrossed on non-judicial stamps. Suppose an agreement is there, agreement normally after 2015, an agreement of sale has to be in a stamp paper of 2050. I mean, I'm sorry, 200 rupees. 200 rupees is a stamp duty that is leviable in respect of an agreement of sale after 2015. At the either two, it was only 100 rupees. But from 2015, it has been raised to 200 rupees. and it has to be on a stamp of 200 rupees. Then once it is presented for registration, then what happens is once it is presented for registration, the sub registrar, who is the registering authority, collects the stamp duty which is leviable, the transfer duty which is leviable, and the registration charges which is leviable, and then takes the money and endorses on the reverse of the non-judicial stamp, or what they call it in Urdu as dastavez stamp, that the entire duty has been paid. Why I'm trying to tell you this is, nowadays a lot of hybrid documents are coming into existence. Now I think I never heard when I started my practice that there's a document called AGPA, Agreement of Sale come General Power of Attorney. It's a hybrid document like what you have today. You have gas as well as petrol on your vehicle. In the same way, it's a hybrid document where there's an agreement, intercede the parties, intercede the vendor and the vendee. The terms and conditions are reduced to writing. The consideration also is mentioned. How much amount has been paid, how much amount is payable is also mentioned. Or let us say the entire amount has been paid also has been mentioned. But they say as far as the sale deed is concerned, we'll get it done at a later date. Then please remember there's a leading case on this aspect that is popularly called in 2004 or 2005 Supreme Court is popularly called the Suraj Lamps case, where whenever a suit is filed for specific performance, if it is regarding to an AGPA, the specific performance cannot be granted unless and until the entire stamp duty is paid and the entire sale consideration is paid. Then alone an AGPA can be enforced in a court of law. That is after the leading judgment of the Supreme Court in the Suraj Lamps case in 2004 or 2005. But please remember why I'm trying to tell you that is I came across such a case in one of our districts of Telangana, that is Siddipet, where there was an agreement of sale which was in the form of an AGPA. AGPA was already registered by the registering authority, and the entire consideration was paid, and the entire stamp duty was paid, and there's an endorsement that the stamp duty has been paid. Then, in that case, the judge was insisting, I think if I'm correct, is the additional district judge of Siddipet, who is now the principal district judge of Karimnagar, that because of the Suraj Lamps case, this specific performance cannot be granted. But successfully, I pleaded before the court, sir, no doubt it's an AGPA, no doubt it's a registered AGPA. But if you look into the recitals of the document, the entire sale consideration has been paid. The entire stamp duty, transfer duty, everything that has to be paid has been paid under the document. And what has not been done is the vendor has not executed a Pakka registered sale deed. And the courts are not helpless under Section 10 when everything is complied with. Suraj Lam's case does not apply. Please remember, sometimes we come across certain documents, sir. You have to be very, very careful. Suppose an AGPA has been registered. Please remember, though the sale deed is not done, your GPA may act funny. He may try to execute a sale deed in his own favor because he is the GPA holder. Because the words which you use in a document, be it an agreement of sale or be it a sale deed, is in favor of so and so, which term shall include all his heirs, assigns, and legal representatives and nominees. The power of attorney is none else than the representative of the vendor. Then he can execute a document in his own favor. But Suraj Lam's case will apply only in such a scenario where the stamp duty has not been paid, where the entire sale consideration has not been paid. Court will not enforce such an agreement. Please remember, whenever you come across immovable property, properties, first see whether the stamp duty has been paid, whether the consideration has been paid, and what you want to enforce through court, as you have complied with all the legal requirements, so that Suraj Ram's case does not apply as far as the facts of your case is concerned. So, what you call is 17B is an amendment which has been brought about by the Amending Act of 2001, and it was effective from 1/7/2001. Then we visualize a situation, sir. Suppose it's an agreement of sale with possession. Agreement of sale with possession. That means possession of the property has been delivered by the vendor to the vendee. An agreement of sale coupled with possession has to be compulsorily registered. Unless it is registered, the question of a sale deed does not enforcement does not come. It cannot be looked into at all because of failure to uh, adhere to the conditions of section 17b. Then most of I think most of you are advocates practicing. There is mostly I think I also was in a doubt earlier to say why do people execute a rental agreement or a lease deed only for 11 months, sir? Because if it is 11 months, the myth or the misnomer which we people have, it doesn't require stamping, it doesn't require registration. That is not a correct position. Even if it's for 11 months, the entire stamp duty has to be paid. That is, for if it is within 3 years, 3% stamp duty has to be paid as far as the rent is concerned, calculating it for 11 months or calculating it for 12 months. But we use the figure 11 months because it doesn't require registration. But after the amending act of 2001, where 17b has been introduced, it says even if it's for 1 month, it has to be registered and it has to be in writing. Then the question is, uh, suppose you don't register it, then what is the position, sir? If you don't register it, or the stamp duty is not paid, the court can impound the document, send it for collection of stamp duty, and you have to pay 10 times the duty that is liable to be paid. I mean, by way of penalty, and the deficit duty which you have to pay that amount, and then only the document will be validated. Then the question arises, sir, if the deficit stamp and penalty is paid, is a document valid? Please remember, you have not registered the document. If you don't register the document, but it can be looked into only for the purpose of a collateral purpose under Section 49 of the Legislation Act, but not for the main purpose of proving a transaction. So these are all the disastrous consequences of not registering a document as per law, because you've got the famous case of Suraj Lam's case, which says even if it's an AGPA, the entire consideration has to be paid and the entire stamp duty has to be paid. You cannot avoid stamp duty at any cost. Then, sir, you take a case of a release deed or you take the case of a relinquishment deed. If you take the case of a release deed or relinquishment deed, suppose it's a joint family, HUF, whatever you may call, and one of the legal heirs relinquishes or releases his rights in favor of the other legal heir. Then, in that case, earlier, I still remember, I think it was prior to 1975, you could execute the document on a stamp paper of 30 rupees and get it registered by mentioning it as they constitute the undivided family, and the person who is getting the releasing the rights is one of the sharers and is releasing it in favor of the other sharer for whatever consideration it may be. That's all. But now, please remember, the government has woken up and said, uh, I told you also the famous thing is, even if both of you agree, the government says, where is my revenue? So that is the reason why a release deed or a relinquishment deed also today is considered as a conveyance, and the entire duty which is liable to be paid as a conveyance, a sale deed, gift deed, or whatever it is, will be collected from you as far as the document is concerned. Now the question is, well, then what are the repercussions? Suppose an agreement with possession, then it has to be compulsorily registered. Without registration, the document is of no value for you. So these are all the various facets under the various laws which governs Section 10. So one thing you please remember, sir, Section 10 has been amended and substituted in 2018. The effect of that amendment is the word may has been removed and it has been substituted by the word shall. Please remember, all of us know English. There's a lot of difference between the word may and shall. May means it is a discretion of the court. Shall means it is mandatory. The court has to enforce the agreement as a contract. Then please remember why these things are maintained. Why Section 10 is provided is that to see that the parties honor the contract, both in the letter as well as in the spirit, and there must be a methodology through which a person should be able to reap the fruits of a contract which he has entered into due to no fault of his. The other side is the violator. The other side is not executing the document as required under the law. Law should not be helpless to come to the rescue of a person who has suffered in the hands of the opposite side. That is the reason why Section 10 has been provided, and it has been made more liberal now because no more discretion of the court. It is only shall. The court shall enforce the contract. Are you able to understand, please? This is what Section 10 says. Then we go to uh, what are the circumstances under which the performance can be refused. One is Section 11, which says all transactions relating to transactions concerning trust or trust property, the trustee has to act within the circumscribed limits of the powers that is granted to him under the trust deed. The trustee has to act himself in a manner according to the powers that are vested with him as per the terms and conditions of the trust deed. He cannot execute a document in favor of the intending purchaser without the powers being granted to him under the trust deed. So, when it relates to specific performance of a contract against trustees, the trustee should have ample power to execute the conveyance and execute the document. But in case the trustee exceeds his powers and the powers are not given to him, but still enters into a contract with the party, then such contracts cannot be enforced. That is what Section 11 says. Then, sir, that is Section 11. Then I shall deal with Section 12 and 13 in the next class. But as far as 14 is concerned, it says, suppose, let us say, you as the person, one of the parties to the contract, are prepared to accept substituted, that is called substituted performance. Suppose I go to a surgeon for an operation. It is subject to so many ifs and buts. That is the reason on the appointed day for the operation, let us say the surgeon should be in good health. I may be a patient, but I should pray for the long life of the surgeon because he is an expert in his particular field. And I want the performance to be done by him only. I don't want any of his juniors to do the to conduct the operation. But let us say it's. I told you also it is subject to ifs and buts. On the day appointed day for operation, let us say the surgeon falls sick or he gets paralyzed, he loses speech power and he cannot use his limbs to perform the operation. Is he capable of performing the act which he has promised on the appointed day? No. Why? Because the subsequent illness, the subsequent incapacity, mental or physical, is unable to do it. But in case you agree, sir, either you can do it. If you are not able to do, ask your junior is quite capable of doing it to perform the operation. Then in that case, when I accept performance from his juniors who can also perform the operation, I cannot complain of breach on the part of the surgeon. This also happens in our legal profession, sir. All of us have our colleagues. We don't call them juniors because it's too degrading to call them juniors. But they are people who are assisting you. But they are equally capable, equally, they have equal knowledge like you, though short in experience. But still, suppose a client comes to you that you alone should conduct the case, sir. You should alone conduct the trial. You should alone argue the matter. None else should do it. But let us say on the appointed day when the trial has to start, the advocate concerned, God forbidding, is affected with paralysis or is suffering from physical or mental ailment or his limbs fail and he cannot do the case. Then he has got efficient juniors with him. He tells the client, sir, I am not in a position to come to court and conduct the case because of my physical condition. My juniors are there. I can instruct the juniors to conduct the case. Are you prepared to do it? Are you prepared to stand by the juniors? Then the person says, whether you do it or your juniors do it, sir, because of your incapacity, you are not able to do it. I'm prepared to accept performance from your juniors. Then the other person cannot complain, saying, sir, the senior has agreed to do the act. He has not done it. Since he has not done it, please compel him to perform his part of the contract. Let him come with crutches or let him come on the wheelchair. And even if he's not able to hold the scissors or forceps, let his juniors hold it. I want performs only by him. That cannot be done. That's absolutely next to impossibility. That is the reason specific performance will not be granted in such situations. Then the next one is uh, uh, then it is said, suppose you accept performance by way of substitution, you cannot complain of breach, and you cannot even go for specific performance, and specific performance will not be granted. Then personals are then next one is not enforceable without data. Suppose let us say the contract between you and the other side is for a definite period. Let us say that period has already expired. And then you sleep like a Rip Van Winkle and wake up slowly and say the other side has to specifically perform the contract. Then, in that case, specific performance will be refused. That's why I made a reference to the time fixed for performance. Article 54 is very, very clear. If the time is fixed for performance, it is 3 years from the date fixed for performance. If no time is fixed, it is 3 years from the date when the refusal comes to your notice. And proviso, of course, you can take advantage of that. Suppose you give a notice calling upon the other side to perform his obligations, he refuses to do it or does not do it, then you can say the period of limitation starts running from the date when the other side has disabled himself from performing the contract. But in all other cases, suppose money compensation is sufficient, or so let us say the contract cannot be specifically performed due to various reasons or various contingencies which arise, then if money compensation is sufficient to satisfy the needs, specific performance is not refused. It's a specific performance is refused. Then, sir, when compensation can be granted, power to engage. Then we go to section 14A, sir, which has come by way of an amendment. I think perhaps some of you are aware of the old Evidence Act, section 45. 45 speaks about experts being appointed for the purpose of doing certain special things, especially especially it's a case of medical negligence, or it's a case of faulty design, or it's a case of damages which has occurred to the building, or it has been done in a very bad way. All these things the court cannot go there and examine. So they have got the right of appointing an expert under section 14A, which says the provide access to that is the when compensate. Next one is 14 experts power to engage experts to provide access to documents, goods, or other property for his inspection. Expert attendance to be ensured. Here, why experts are appointed is people who are experts or professionals, or as far as a particular sphere of activity is concerned, court has got the power under 14A to appoint experts, and they should be given access to the documents. Then they must be given access to the that is what is called goods, or they must be given access to various things for inspection, and the expert will enter the appearance and then conduct the give this expert opinion, and his expert evidence has to be ensured, and he can be examined in the court also, and his whatever is his service charges or whatever is the remuneration has to be paid by the party concerned. So expert evidence sometimes plays a very important part. I think in the CPC also, or the Evidence Act, I'm sorry, it's not in CPC, but in the Evidence Act, Section 45 provides that whenever there's a dispute regarding handwriting, whenever there's a dispute regarding the signature, whenever there's a dispute regarding a particular aspect which only the expert can determine, then in those cases, an expert can be appointed under the provisions of Section 45 of the Evidence Act. Or there's a dispute regarding the uh, or let us say the ground is alleged that forgery. The question of forgery, only the expert can give an opinion. Why, sir? Expert can give an opinion because he has got the technical acumen, the knowledge. He uses the set square, uses the scale, uses the protractor, measuring the strokes. style of handwriting, style of signature, so on and so forth, then an expert is normally appointed to inspect the documents, to inspect the goods, inspect the property, and give his opinion regarding the matter which is referred to him. Here, in this case, sir, I could tell you that uh, the court will not embark on an inquiry. Court is not an expert to know every field of activity. Court is also restricted as far its knowledge is concerned. That is the reason why they take the assistance of the expert to examine and then give his opinion. And the expert is normally examined in the court. His charges will be paid, his professional fees will be paid, and let us say the BATA also to summon him will also be paid, and then he's examined in the court and his evidence will be evaluated. So 14A provides for access to provides that experts can be appointed by the court to give their opinion. Then we go to the last section, one more section called section 15. 15 speaks about who may obtain specific performance. Here, I would like to tell you that there is a doctrine called privity of contract. Privity of contract is contract binds only privies to the contract. A stranger to a contract cannot sue on the contract, and the contract has to be enforced or implemented only by a party, only by a privy who is a party to the contract. Only those people can enforce the contract. But Section 15 says, suppose let us say either party, I'm not talking about the vendor, I'm talking about the vendee. Suppose the vendee comes for a suit for specific performance, or let us say before he files a suit, he expires. His legal heirs, his transferees in interest, his executors who implement the intention of the party, or anyone who is interested, who is a successor in interest, can always approach the court and file for specific performance. It is not necessary that only a party to the contract should bring a suit. It is sufficient whether a legal representative, transferees in interest, or assignees, or the executors also can file a suit as far as enforcement of the contract. That's what Section 15 says. So the doctrine of privity of contract does not apply as far as Section 15 is concerned. Um, yes. Of course, next time I'll be dealing with the other sections of the specific performance, and more particularly section 12, section 13, 17, 16, 17, 18 and all. So we have got sections up to section 24. But please, the highlight of this today's lecture is that section 10 of the Specific Relief Act has been amended. The word may has been removed, substituted by the word shall. So no longer specific performance is a discretionary remedy. It is available to you as a matter of right. At any time it can be enforced. And once there is an agreement, it shall be executed in the letter as well as in the spirit. And please remember, specific performance would lie only regarding executory contracts and not executed contracts. I also discussed section 9, the defenses that are available to a defendant. That if whatever defenses are available under Contracts Act for discharge of the contract, like doctrine of frustration, then what is called novation, remission, alteration, or variance, or let us say vitiating elements of contract, those defenses the defendant can definitely take and plead it and then prove it and establish it. So that is section 9. Section 10 is who may sue for specific. That is section 10 says how it's enforced. They say all suits whenever there's an agreement that can be specifically enforced, may be specifically enforced. But the word may has been substituted by the word shall by the amending act of 2018. The rest of the sections I shall discuss it tomorrow, please. Now the interaction starts. Any questions, please?
Can you explain privity of contract, sir?
Privity of contract means parties. Privity means privy. The word privity comes from the word privy. Privy means party. That is only a party to the contract can enforce a contract. That is privy means a party to the contract. A person who is a party. Pardon? PRI, is privy. PRIVITY is privity.
PRIVITY.
That means it says previous to the contract alone can sue on the contract. A stranger to a contract cannot sue on the contract. But as far as Section 15 is concerned, it is an exception which says if either party is not present, the legal representatives, transferees in interest, successors in interest, assignees, or the executors can maintain an action. They can also sue for specific performance. So 15 is an exception to Section 10, sir. Am I making myself clear to you, please?
Those who are interested in the contract can file a suit.
They can file a
Is
suit.
what
But in case, let us say, one of the parties who's filing a suit is not available or is dead and gone, then in that case, his legal representatives, his transferees in interest, or the persons to whom the contract has been assigned, or an executor who has to implement his intention, they can also bring a suit on behalf of the dead person, sir. That is called, is Section 15 is an exception to Section 10. Am I making myself clear to you, sir?
Thank you.
Yes. Pada di ba kau nak kata dia kata di mana di puri K.Santhanam.
Mr.
Somebody's.
Mr. Alok. Mr. Satyanarayana.
Sir, this one is 11 months rental agreement. Can you explain, sir?
Yes, sir. Previously, before Section 17B was introduced by the Amending
Yes.
Act of 2001, it is said 11 months agreement, suppose you take, you only pay the stamp duty, that is 3% of the annual rent you pay, you purchase stamp and then engross it on that. It didn't require registration. But after the Amending Act of 2001, even if it is for 1 month, it has to be in writing and it has to be registered. And without registration, the document is a nullity, sir.
Oh.
So it is
Now,
not.
normally people will be writing on 20 rupees paper.
అందుకే అంటారండి, so long as, that's why they say మియా బీవి రాజీ తో క్యా కరేగా కాజీ. Suppose both of them agree, the question of there is no dispute. But please remember, as advocates, do you allow them to agree, sir?
Yes, no, sir.
లేకపోతే
But see, they
లేకపోతే
won't take it for stamp duty, sir.
Exactly.
Only they say, sir, 20 rupees paper lo రాసేయండి, sir.
even companies are doing it, sir. Unfortunately, they're guided by company secretaries. They don't give them the proper advice.
Yes, sir, that's what. He
And-
himself will pay 50 rupees paper and one man
And,
gives us, sir, right?
unfortunately, as advocates, we have to bear the brunt.
Yes, sir. So that is not at all valid, no, sir?
No, it can be
11
looked only for a collateral purpose, not for the primary purpose.
Collateral purpose.
Under Section 49, it can be looked into for a collateral purpose to show the transaction, that's all.
Sir, if it is more than 11 months, sir, if it is 2 years, 3 years,
If it's 2 years and 3 years, it's 3% of the annual rent, sir. If it is beyond 5 years, it is 5%.
5%. The rent has been that to be.
Another
Dep-
thing, when you get it
Thank
registered,
you.
I wanted to amplify also, sir. If you are getting it
Yes, sir.
registered, even the premium which is paid, the advance which is paid also has to be added on to the annual rent.
Oh,
Yes, sir.
it was also.
Why
Is
am
that 3%?
Yes, sir.
3%
plus
with stamp
plus the
duty.
advance, plus the advance. And when
Plus
you
the advance.
yes, sir, when you
Ah.
file a suit for suit also, when you calculate
sir.
under Section 40, you have to add the advance also and then pay the court fees. If I'm correct, it's Section 40 bracket 2 court fees act.
Acha, party. Yes, sir. Yes. But, sir, some people only 11 months is enough, sir. Not 2 months, even 11 months will renew. Like that, people will be saying.
Please
sir.
remember, don't guide them that way, because if they do it that way, when it comes to
Ah.
court, you have to pay the penalty of 10 times and the actual duty to be paid.
Yes. So, no
And-
need of 11 months. Any number of years you can write.
You can do it, but you have to pay the stamp duty
Stamp duty.
and get it
Not
reg-
simply
and get it
it is to be registered.
yes,
Registered, no, sir.
compulsory registerable.
Okay.
That's
okay,
why I said
sir.
release deed also those days. We used to mention it
Yes,
as a
sir.
joint family, and one of the sharer purchases the share of the other, or one person releases his share in favor of the other
Ah.
person. Then we used to get it typed on a 30 rupee stamp paper and get it registered. But now the government has woken up. Government has said even that is treated as conveyance. You have to pay the regular duty. So
Oh,
that's why they say even if parties agree, the government comes in the way. They said, where is my revenue or where is my share?
Yes, sir. Yes, sir. Sir, in this will partition, sir, suppose a father has written a will for his 3 sons,
Yes.
and they wanted to the partition deed they have to put again.
Not necessary, sir. Under the will, the status which was undivided earlier becomes divided. Each one gets
Yes.
his respective shares. If and normally in those circumstances, they get that the old man gets the will also registered, so that it becomes a public document.
Yes, sir. The will was not registered, sir. Simply written and is demarcated the
No,
property.
as far as Hindus are concerned, will doesn't require compulsory registration, sir.
Yes, sir. That's what
Except in the case of a Christian. Christian will has to be properly registered, and then letters of administration also has to be taken as far as Christians are concerned.
Yes, sir. And this year in that will, sir, he has demarcated for his 3 sons.
Yes.
What is the property? What is the demarcated the property also?
Right.
Then there is no question of partition deed again.
Only
no,
thing is after the demise of the testator or the testatrix, the parties
Yes,
can
sir.
approach and ask for subdivisions to be made.
They approach the court, na, sir, again?
Not necessary, sir. They can straight away go to the corporation or the Gram Panchayat to give subnumbers and separate assessments. And
That's
for,
all. There is again
and for
no legal requirement.
not
for
necessary,
them,
sir, for mutation also.
mutation also.
Yes,
Simply on the basis of the will, they can do it.
exactly. But as far as Hindus are concerned, there is no need of getting it registered, no need of getting it probated. But one difficulty is there. There they say, suppose the executor who has to implement the will says, don't don't implement it till you hear it from me. Then it will be frozen. In that particular case, unless the executor gives his clearance, the dog. I faced such a situation in one of the cases. What happened was a old lady that is belonging to the Binani cement. That is Govind by Binani. She executed a will whereby she appointed her brother-in-law as the executor, and then said there was about nearly 10 crores of assets which were to be distributed among the daughters. She gave 3 crores to one daughter, 3 crores to another daughter, a building to another daughter, and then something else. Then the executor, who was the brother-in-law, he played dirty by saying that don't pay the monies to the beneficiaries. Then in that case, what happened? Yes, sir. The bank involved was in the Sindh Bank. The Sindh Bank was insisting on a probate being obtained. Then what happened was a OP was filed for grant of probate. The judge fumed at me and said, sir, why did you not make the bank as a party? Then I said, sir, if I make the bank a party, then what would happen is it will be a prolonged trial. And the question is, if I make the bank a party, the matter cannot be disposed of early. Then he said, the judge was saying, sir, if you had made the bank a party, I would have imposed cost on the bank and exemplary costs. But I said, sir, I am interested. I said, I am interested more in my fees than the party's money.
The bank.
Yes, sir.
Yes, sir. Yes, sir.
That's a practical way of looking at it.
Yes, sir. So the will, once the will is written and after his death, this need not be again go to court and
not necessary, sir. That's why it's called testamentary transfer. And there is yes, sir. And they also use a sentence: "This will shall be my last will and come into effect after my demise."
Yes,
and I reserve my right to cancel or modify this will anytime during my lifetime. That's a clause normally written.
Normally, this is the last whichever will was written.
Normally, as a professional, sir, what I do is, if the widow is surviving, then in that case, I said a life interest is created in the name of the widow, and after her lifetime, it should go in a particular way. Because if everything is given to the sons, the widow will be driven out of the house.
Yes, 100%, sir. That's why I am also writing nowadays like that only.
Because ade antarante laukikam antar lokamla, you can't trust anyone.
Sir. That lady will be ignored by these daughter-in-laws.
Exactly, sir. So long as the cream, is there, you will be looked after, sir. Not otherwise.
When they having some property only, they look after.
Exactly, sir. Exactly.
Then, sir, only in the municipal records, if the property is municipal or whatever revenue records, it can be mutated. That's all.
Based on the will.
Based on the will only.
But one thing, some curious defenses are being taken by the local authorities, sir. What they say is, you file a suit for declaration of legal heirs based on the will.
Acha.
Unfortunately, yes. Unfortunately, they have been guided by half knowledge of law, sir. That's a problem.
Yes, sir. And 9 children, and he has given the will for only 3.
Yes, sir.
That 3 boys, the other 6 daughters, he has not written.
Then
In
the
2009.
yes, sir. The
2009,
question,
sir.
2009.
It is
The question arises whether it's a self-acquired or ancestral. But
it is a self-acquired. It is a clearly written self-acquired.
even if it's self-acquired, daughters get a share, sir, because they are class 1s.
Yes, but he has written in that will, I have given already married and I have given certain gold and other
What
things.
are you giving?
So
to,
I need not give anything. All these things will go to my son. So
not necessary, sir. 29, please remember the greed of
Yes,
a
sir.
person. The sons-in-law come to you for legal advice, sir. It's not the daughter who comes to you. So the question is, file some suit. The brothers
so
come.
that will is valid, sir. Then,
Will is definitely valid, sir, but you cannot forego the shares of the daughters, isn't it, sir?
but daughters is clearly written. Daughters will not get anything.
Even if you have written what is extra which you are going to give to me, sir, that's normally asked.
He has clearly written. I already done the marriages, everything. I did not give a single rupee to
Sir,
them.
shall I tell
So
you, sir?
whatever the amount, I will go to all the 3 sons as per the
Sir,
my given schedule.
in one of the Telugu movies, sir, I saw a son says, "Why have you given birth to me? Because to satisfy your carnal desires, you have brought me into existence.
Yes.
So you
Yes,
have to
sir, yes.
you have to support me throughout my life."
Yes. Correct,
Here
sir.
in
I
India,
also Dasari Narayan Ross movie.
అదే చెప్తున్నాను నేను అదే మూవీ చెప్పలేను మీకు.
Correct, sir. That
Yes.
is, I have also seen that movie.
తాత మనవడు. తాత మనవడు.
Tata.
Yes, sir. Next, sir. Yes,
Hello, sir.
Yes, Mr. Vasantrao.
Sir, good evening, sir.
Good evening.
Sir, what is contingent contract, sir?
Pardon?
Contingent contract.
Contingent contracts. When I come to contracts, I'll discuss a contingent contracts means here, suppose let us say it is depending upon the happening of an event which happens or does not happen, or it is based on a condition precedent or a condition subsequent which may or may not occur. Then it is called a contingent contract. Suppose let us say A says, "I will give you a property if you marry C's daughter." Then in that case, that has to be performed before you take the property. That is what is called a contingent contract. Next.
Okay.
Yes, yes, Mr. Srinivas. వసంతరావు గారు ఇంకా ఏదైనా ఉందండి?
Earlier I didn't talk, sir. Someone was talking, sir.
Yes, sir.
Sir, what is, please elaborately explain the collateral purpose.
Collateral means, yes, sir, secondary. For example, suppose a document cannot be looked into for a primary purpose, but to know the relationship of the parties, the transaction between the parties, the nature of the transaction between the parties, or what position they occupied as far as the contract is concerned, it is called a collateral purpose. Am I making myself clear to this?
One second, please repeat.
Collateral purpose means, suppose let us say, what is the relationship between the parties, what is the transaction between the parties, and what is the essence of the contract between the parties, what are the terms and conditions that are agreed upon by the parties, and what are the conditions that are imposed in the contract. All those things are supposed to be a collateral thing. But main thing is to prove the document itself. You have to follow the law. That is, you must get it registered or on proper stamp. If you don't do it, it cannot be looked into for a primary purpose. But other things which are secondary or ancillary, which goes to prove the relationship between the parties, they are called collateral acts.
Sir, one thing that is a Sada paper.
Sada Bainama, that's what I referred to also. In Telangana, it was done during KCR's time. They said even if a document is on a plain paper, it is not properly stamped, it is not registered, the discretion was given to the revenue authorities to accept the document and collect the necessary stamp duty as per the rules and endorse saying that the entire stamp duty collected white challan number so-and-so, and the document is given effect to. That is what is called Sada Bainama. Sada Bainama, it's only in Telangana, sir.
Sir, my doubt is, agreement of sale with possession was written on a
It is compulsory registerable.
then it will based on that can we file any suit against it?
Oh, you can definitely file a suit. Suppose your document is registered.
Not registered.
If it's not registered, you pay the necessary stamp duty, validate it. It can be looked into for the main purpose to say that the stamp duty is paid, but you have been put into possession. All those things you can prove as a collateral purpose.
Okay, thank you.
Yes. Under section 49 of the Stamp Act.
Alok, sir.
Mr. Alok.
Sir, good evening, sir.
Good evening.
Hello, sir.
Yes, let Mr. Alok finish it.
Alok.
Good evening, sir.
Good evening.
Sir, before filing suit for specific performance of contract, is it necessary to send the notice to the
Sir,
vendee?
our High Court has said notice is mandatory. Our Telangana High Court.
Sir, I am practicing in Mumbai.
If you're in Bombay, it's absolutely not necessary. It's optional, sir. One advantage by giving a notice would be you will know the defense of the other side so that you can prepare your suit in such a way meeting the defense of the other side also. Are you able to follow, Mr. Alok? Even if you're practicing in Bombay to know the defense of the other side, it is advisable to give a notice.
Sir, thank you, sir. Thank you, sir.
Welcome, sir. Mr. Avinash.
Sir, continuation of the Mr. Alok's doubt, sir.
Sir.
The specific performance limitation is for 3 years.
Yes.
The mandatory period of issuing notice after the exhaustion of contract.
Right.
So, is it within 90 days of exhaustion of contract?
Sir, I said, sir, before the 3 years is coming to an end, normally
Yes.
we give a notice to the other side, or even thereafter, we give a notice. Then the other side keeps quiet, does not reply to your notice, then it is deemed to be refusal to perform the contract. Then in that case, you come under Article 54 proviso.
Yes, sir. But
That is the reason why notice plays a very important part.
the period of notice is to be after completion of the contract.
No, it should
That
be
is
before the contract comes to an end, sir.
notice to be issued before the completion of the contract.
Mostly about 2 or 3 days before the contract comes to an end.
After that, notice has no validity.
Yes, sir. That's the reason why, if you see, most of the advocates, what they do is they say the vendor hereby undertakes to execute and register the sale deed as and when called upon by the vendee. Then time is not the essence of the contract. That is section 55(2) of the Transfer of Property Act. And then when you give a notice and it's refused or not replied to, then you get a fresh period of 3 years from that date, from the date of notice. That's where the notice plays a very important part.
Sir, even though if there is as and when required by the vendor,
Yes.
Sir, even then there is a limitation of time saying that within 45 days or within 90 days.
Even if that time is there, I call upon you only 1 week before the expiry of the time. The question is, time is not taken into consideration because of the clause as and when called upon. I can call upon you at any time. That is the ambiguity as far as law is concerned.
Sir, then the validity of the time will not have any existence.
Time is never considered as the essence of the contract. At the most, even if you take time as the essence of the contract, the money compensation will be granted, but specific performance will not be granted.
Will not be granted. Yes.
Yes. Next, please. Mrs. Anuradha Bakkaraju, please.
Sir, as per section 50, the legal heirs of vendee upon action, they may perform the contract.
Right. See, I'm saying on both sides, madam. Suppose, let us say, the vendor dies or the vendee dies, his legal representatives can enforce whatever clauses it's required, or the vendee's legal representatives also can bring an action. So the action which has already accrued during the lifetime of the deceased also passes on to the successors in interest. So privity of contract does not apply as far as section 15 is concerned.
Suppose the vendor is alone, he's got no legal heirs or anybody to succeed upon him.
Yes.
In that case, what happens?
In that case, whoever is the next of kin, that is his nearest relation.
What if they are not opting to?
Even if they are
enter
not
into-
there, then the question of distant kindred also. Distant kindred means remotely connected with him or related to him.
Suppose none is available.
Then the question is
Next friend.
contract works itself out.
Sir, there is also a chance of next friend.
Next friend is I told you, cousin or his friend, his closest friend, jigri dost and all.
Yes.
That is.
Or suppose the property vests with the administrator, let us say, it eschews to the state. The state has to execute the document. Am I making clear, madam?
Yes, yes. Sir, one more thing, sir. Santhanam, sir.
Yes, sir.
When bill, daughter has claimed that bill was not written and it was forcefully written by his sons. Then the attesting witnesses are there, no, sir. What is the role of them?
The attesting witnesses only testify to the fact that they identify the signature of the testator. They are acquainted with the signature of the testator. Testator signed in their presence, and they countersigned after the testator signed, and having witnessed the incident or having witnessed the execution of the will. That's all.
But he need not be called again, sir, when the dispute arises.
He will be called definitely because one party relies on the will, other party disputes it. So the person
Other party disputes, the daughter disputed, and then they wanted the court. The Supreme Court has called the witnesses. Then 2 witnesses died.
Then in that case, the question is whoever would identify the signature of the testator or the attesting witnesses or under section 73 of the Evidence Act, court can itself compare the admitted signatures of the testator and then compare it and come to a proper conclusion. Court itself can do it.
Whether it is by force, fraud, or this thing.
Then all the circumstances can be gone into by the court, sir. It's very difficult to prove that way because the question is,
force. He has given, sir, force, fraud, and fear.
If it is there, then elements of fraud will have to be pleaded. Elements of fraud has to be established. Or the health condition of the testator at the time when he executed. Then whether say he was down with COVID and all, where he was not accessible, the signature was forced. All these things are there, sir.
Signature is correct, sir. It was by force and by doing fraud. And this thing they made him to write
it is easy to plead fraud, but the ingredients of fraud has to be pleaded. The intention of deceit, intention of deception.
Fear also.
Exactly.
By fear.
Coercion.
Force and fear. Force and fear he has given, sir. Actually, in the top line only written without anybody's force and without any fear, I written this. Like that.
That's why they say, in witness whereof I've set my hand and affixed my signature voluntarily without any compass.
Then they asked for the witnesses, but unfortunately both witnesses are died.
Yes.
And court said one witness also is there, we'll accept.
Yeah, one attestor has to be examined, sir.
At least one attestor.
Has to be examined.
Either legal.
Yesterday, one question was asked by someone. They said, sir, one witness has turned hostile, sir. What to do? The second witness is available. You can examine him. Nowhere it is said both the witnesses have to be examined, sir.
No, one witness is right, sir. Then only one witness is available and is hostile in what taken.
Then in that case, under section 73, the court, if you are able to show some signature of the testator, it can be compared by the court itself, or it can be sent to the expert under section 45 of the Evidence Act.
Yes, sir.
Yeah.
So even the legal heirs of the witnesses can come and identify the signature belongs to our father as witness who has signed, or father, or whoever.
Perhaps if they can identify the signature, or they're acquainted with the signature, they're acquainted with the handwriting, the strokes which are used, so on and so forth.
That is regarding the forgery of the signature or something, but they made him to put under pressure and force and fear.
But
so that he has written like this.
But
how it can be proved,
easier said than done, sir.
Sir.
Yes. Mr. Sam from Mumbai.
Yes, sir.
Yes, sir.
Sir, thank you, sir, for giving an insight, sir. I have a follow-up question on the same someone asked regarding
I think you only asked
11 months of rents.
Yes, sir. 11 months, earlier we used to write it as 11 months because we could avoid registration. But the stamp duty you have to pay because it's 3% on the annual rent. You can't avoid stamp duty. But some candidate here who's participating in the Zoom was telling me, sir, they get it written on 20 rupees or 50 rupees or 100 rupees. Please remember, once it goes to court, 10 times the duty will be collected as penalty and the document will be impounded and cannot be looked into for a main purpose, sir.
Okay, so it's necessary to register even if it is 11 months.
No question
Is
of
that the point, sir?
no question. Now it's mandatory and compulsory that should be registered under 17B.
So even for 11 months also it should be registered.
Registered.
Okay. Sir, one more question, sir. You said regarding the will, based on the will, the segregation of the property will be done, like going to a GHMC or Gram Panchayat.
Yeah.
How about sub-register, sir? How do we get a separate document executed in sub-register?
No, you can't get a separate document executed. You can only get your mutation done before the local authorities. But say sub-registrar will not register it.
Then
Only thing is you can ask
the
for
parent
you can only
the
ask
parent
for,
document and the will document would be the title of the shareholders, right?
the title of the shareholders will be recognized with the local authorities by subdividing the property by 1, by 2, by 3, by 4. They will give separate numbers, separate assessments will be made.
Okay, so sir, what if one of the shareholder want to avail the mortgage loan or he want to sell?
Then in that particular case, what he has to do is he must get the property mutated in his name and the parent document that is of his father or whomsoever it may be, and plus the will through which he has got the legacy, it has to be submitted for loan, sir.
Okay.
Yes.
How about to sell, sir?
Pardon, sir?
If he has to sell that property, or
if he has to sell, all these formalities have to be complied with, sir. Before that, he cannot sell it.
What is the formality, sir?
Formality, I said you must get it mutated in your name based on the will.
Okay.
And you must get a subdivision made and so on and so forth.
Okay.
That's the reason it's advisable to get the will registered, though it doesn't require registration.
Okay, sir.
Okay.
Thank you, sir.
Welcome. Next.
And sir, you told that section 10 is, section 20 is an exception to section 10, sir. How it is?
I am not come to section 20 as it, madam. As and when I come, I'll compare both 10 and 20, madam. Yeah. Yes, next, please. Any more questions?
Sir, one more question from my side, sir.
Yes, madam.
Recently, the municipal authorities, when I approached for testamentary transfer to property, they were reluctant to do it unless it is probated. So I told them the will is not compulsory to be registered.
Under section 18, it's not compulsory registerable.
Yeah, that's what I told him, but they were reluctant.
Yes.
So what remedy can I?
The only remedy open to you is, based on the will, you file a suit for declaration that under the will you have got that particular property. The GHMC is not recognizing it. Please give a declaration that I'm entitled to get things done by the GHMC based on the will. So you get a declaration that you are the beneficiary under the will. Unfortunately, people who are managing these local authorities have no knowledge of law. That's a problem.
Yes.
Even if there are law officers, I don't know whether they have studied law or not, or whether they copied in the examination and passed.
Thank you, sir.
Welcome, madam.
Any more questions, sir? Okay, sir, that's fine. Okay, good night to all. Thank you.
Good night. Good night.
Good night, Varlakshmi.
Good night. మీ పేరు బాగా గుర్తుపెట్టుకున్నారు అమ్మా. మీ పేరు బాగా గుర్తుపెట్టుకుంది. అనురాధ బకరా. మీ ఫ్రెండ్ ఉంది కదా గౌసియా. ఎవరిట్లా మరి జాబ్ చేసేస్తారా యూట్యూబ్లో ప్లీజ్ చేయాలి That 8:30 terminated, madam.